Hi, I'm Shan Wu with a Undercolor of Law hot take on what it was like inside the Supreme Court courtroom when they handed down the presidential immunity decision. So I've been at the Supreme Court before, but I've never actually been there for when they make the announcements. So it's kind of an interesting experience to go there. So for those of you who haven't been to the Supreme Court before, it's actually it's a very gaudy looking place. They have these giant ceiling to floor red velvet drapes that look like they've been there since Roman times. It's very much the look of the court. It's got like 23-foot high marble columns throughout the courtroom. So there is a very much sort of Greek Roman feel to it. And it's also very much stage-like because of the curtains, and the judges actually come out from behind the curtains. You don't see that in most courtrooms. The judges aren't behind curtains usually. So in the courtroom, it's a fair amount of anticipation. There usually is. There's a section for the public to sit in, and there's some reserved areas there. And then there's also a section closer, kind of like in the pit, for the members of the Supreme Court bar. Those are the lawyers who may be arguing the case or other members of the bar who can sit there. So beforehand, one thing I was really struck by was the Supreme Court security folks only face the audience. So they're facing the audience. They have their backs to where the justices will sit, to where the lawyers will be. It was very quiet. I mean, you could tell there's some excitement, but people are not talking very loud. But the security was like saying shh, shh, and just kind of telling everyone to be quiet, which I thought was kind of weird. It's like they were anticipating as though there was going to be noise. And there's like never noise in the court. I mean, it's a very strict, very, confined kind of environment. So ultimately, I thought it ended up being a little bit of a metaphor for why they were telling the public to be quiet, because it was as though they were anticipating a problem which had never happened, really. And that actually was very much like what happened in the actual majority opinion that Chief Justice Roberts delivered from the bench. So it started out pretty matter of fact. And again, the atmosphere was, I'd say, pretty lighthearted. Justice Amy Coney Barrett actually first read an opinion she'd read, not about immunity. And she even made a little bit of a joke. I mean, she was much more kind of like personable than I expected her to be. She made a joke. This was not what everybody was there to hear, and she would be quick. And she wasn't quick. But then when they got to the immunity decision, everyone was very wrapped in their attention. And Chief Justice Roberts read it very matter-of-factly. There's no kind of like dramatic intonation to it. He just kind of read straight through it. And notice two things. So he's been criticized before for not really giving enough attention to the detail of Trump's actions around January 6th. This time he spent a fair amount of time talking about the allegations about Trump's failures, not calling for the security, not calling for police, the fake electors scheme. So he gave a lot of time to that, although ultimately the decision itself was extremely pro-Trump. The other thing I noticed atmospherically was the rather disengagement of the other conservative justices. I mean, Justice Thomas literally looked like he was leaning back in his chair and resting his eyes at times. Alito, I mean, this may be a stereotype, but I can't help but say he looked rather smug. I mean, he would be looking down like he was doing something while the Chief Justice read. The only person who gave the appearance of paying lip service or facial service to the reading was Brett Kavanaugh, who actually would look towards whoever happened to be reading the opinion. His expression, I wouldn't call it very alert. I mean, it looked a little bit sort of like expressionless, but he would turn his face towards whoever was reading the opinion. So Ed Gorsuch was absent for some reason, so there's an empty chair there. As he read the opinion, again, very matter of fact, and then I did notice that Coney Barrett seemed much more, I'd say, uptight. She'd lost the sort of like happy vibe that she had when she was reading her opinion. It may have been because she was anticipating what Justice Sotomayor's dissent was going to be like. They would know what the dissents are because they've read all the opinions ahead of time. So when it got to the dissent really took apart the majority opinion. So let's just talk a little bit about the substance here, which you've probably all read about already. My main beef with this case is that The U.S. Supreme Court didn't have to take the case. As we know, they have 100% discretion. They don't really have to take cases. People can appeal as a right to them in certain kinds of cases, but that doesn't mean that the court has to take the case. Here, Judge Chutkan, as well as the D.C. Circuit Court of Appeals, had done a very good job in the lower court decisions, particularly the D.C. Circuit, which took a little bit longer than we wanted. But they wrote a very strong opinion rejecting Trump's claims of absolute immunity for presidential actions. Nonetheless, this Supreme Court took the case, and then, boy, did they take a long time after the arguments to decide it. Perhaps not long by normal Supreme Court standards, but again, they've shown the ability to expedite things when they want to. For example, when Trump was going to be kicked off the ballot, they almost immediately got to that case and said, no, he can be on the ballot. So, why did they delay so long? Speculation, they're being partisan just to help him, possible, or that there was a lot of negotiations over the opinions to be sorted out. Now that we have the opinion, I don't really buy the second one. Was straight down partisan line, 6-3, right? 6 conservatives against the 3 progressives. So I don't know how much negotiation there would have been. So the heart of the decision is that the majority is so worried that if American presidents are ever prosecuted, that in the future, presidents will be really worried. They'll be paralyzed with indecision because they fear that anything they do might subject them to prosecution later. Pay no attention to the fact that that's never actually happened in almost 250 years. No other president has been charged with anything. So the fact that the majority was so concerned about this danger that has never happened before seems kind of silly. Also, they make a big show of talking about the Constitution, of course, and the historical precedent and how there's never been anything like this before. Again, there's never been anything like this before because it hasn't happened. No other president has done anything like this. Now, there are 2 concurrences. Justice Thomas also concurred, and he wrote sort of an unnecessarily long concurrence, I thought. But his whole beef was that he felt that the special counsel, Jack Smith, was an unconstitutional appointment. So that was what Thomas wanted to say. Amy Coney Barrett, very interesting, wrote a separate concurrence. And, I've said before, she is no savior for the court, but she is showing some splits in terms of her legal analysis from folks like Alito and Thomas. And interestingly enough, she is the one who was not previously served in a Republican administration or any administration. She was a law professor. So some of that basic DNA may be starting to show itself, because a part of Chief Justice Roberts' opinion that was particularly irritating was after they make these distinctions between the kinds of immunity, one of the points he made was very much of an evidentiary one. And let me talk about that in a second. I'll give you the 3 buckets first. First thing they said was bucket 1, core presidential powers, total absolute immunity. What's an example of that? Commander-in-chief. You cannot second guess anything the president's doing when he's acting as the commander-in-chief. Okay. Bucket 2, not core, but official acts. What's an example of that? SCOTUS suggested an official act might be if the president's talking to their attorney general, which Trump did, trying to get Barr to help him overthrow the election. That's walled off. Can't look at that because it's an official act. He's talking to his AG. Maybe also when he talked with Mike Pence, trying to get Pence to unconstitutionally stop the Electoral College count, but he is talking to his VP. Maybe that's an official act too. Third bucket, non-official acts, purely private acts, no immunity. Those, you would think there'd be some no-brainer examples of that, which Sotomayor's dissent pointed out, which is when Trump is talking purely with his private attorneys, getting them to gin up these nonsense arguments about challenging the election, the fake electors, etc., that seems like a purely private act. There's nothing official about that. Even those, however, SCOTUS said, we can't really tell. All this, they kicked back down to the trial court to say, figure it out, develop the record, give us a better record. But those are the 3 buckets. Going back to Amy Coney Barrett for a second, the bucket that she had a problem with was the official powers bucket, Chief Justice Roberts said, even if you have private acts, the evidence to support that case based on private acts, you can't use any evidence that might be under the official acts. What's that mean? Let's say Trump took a bribe for appointing someone. If part of that was he was talking to someone to order them, hey, appoint so-and-so the ambassador, I got money. That communication, appoint so-and-so because I got the money, that can't come in because talking to the Secretary of State, that's an official act. So Coney Barrett correctly pointed out that that doesn't really make any sense. That's an evidentiary question. It doesn't go to immunity, and it's going to hamstring any prosecutions here. So that was kind of her point on that. But just a concurrence is really just people expressing their opinion. So let's go to the power of Sotomayor's dissent. So first of all, she points out that history is really on her side, and Justice Jackson, who also joined her, and Justice Kagan, meaning the Constitution says nothing about there being presidential immunity. It simply doesn't exist in there. In fact, if you go back to sort of this originalist notion of what did the framers intend, in the Federalist Papers, it's pretty clear that the framers contemplated the possibility of a president being held accountable for committing a crime. They probably just didn't think was going to occur that often. And it hasn't. In 250 years, first time we have a president charged. Sotomayor, really takes apart what the majority has done here, saying that in creating this very torturous series of buckets, it makes the immunity so powerful that it would be nearly impossible to charge a president for acts that happened while he was president. And it was a great dissent. It was very powerful, and she punctuated it by turning at times to the conservative side. Amy Coney Barrett, who was kind of sitting next to her, was staring straight ahead. But Sotomayor would turn towards the Chief Justice to kind of punctuate particular parts of her dissent. And one important part of that dissent was, it's very traditional that in dissenting opinions, that the word respectfully is always there. The justice who's disagreeing will say, I therefore respectfully dissent. She omitted that. It didn't say respectfully. Same thing with Justice Jackson's concurrence, omitted the word respectfully. And what really struck me was, as she turned towards Roberts to make these points, in normal conversation, someone's turning towards you to make a point. We do this on TV all the time. You kind of make eye contact. You look like you're listening. You nod, maybe you smile. You do something to include them. Roberts did none of that. He didn't even look up at her, didn't make eye contact, didn't acknowledge the fact that she was speaking to him. And in that, I really saw the enormous isolation of the liberal wing of the court now. They are isolated. There is no working with the conservative wing. And as she pointed out, this group of conservatives simply changes the law based on, as she termed it, brute force. So that was my take on being in the courtroom for this presidential immunity decision. Immediately what happens goes back to Judge Chutkan to figure out which of these things might fall into which bucket. That's going to be appealed. And then that appeal to the DC Circuit will then go back to the U.S. Supreme Court. So we can see that this process is not ending anytime soon. Thanks for watching. Keep those comments and replies coming. Really appreciate getting to see them. Talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.